My name is Stephen Whelan, spelled S-T-E-P-H-E-N, and I'm representing myself today. The issue here today is related to a settlement proposal and subsequent award for attorney's fees and costs. It's my contention that the proposal is invalid because it does not meet the relevant statutory requirements or civil procedures. Furthermore, the trial court abuses its discretion by finding that the settlement proposal was made in good faith. And lastly, the trial court further abused its discretion by failing to grant a rehearing as a result of multiple errors of law identified in the motion. I've got 7 points that I'd like to discuss here, and I'll take them one by one, and I'd like to leave 5 minutes for the rebuttal at the end if I could. The first point is the settlement proposal did not name the parties. The relevant Florida statute here is section 768.79, and which governs the requirements of settlement proposals and the recovery of costs. The paragraph 2 and 2b of this says an offer must name the parties making it and the party to whom it is being made. Notice the word name there. The Florida Civil Procedure 1.442 describes in the form and content of the proposal for settlement in paragraph 2, a proposal shall name the parties or the parties making the proposals and the parties or parties to whom the proposal is being made. Both of these citations state that the offer must name the party. It doesn't say infer, imply, deduce, or indirectly identify or otherwise refer to the party. The next point I want to make is that the statute should not be interpreted beyond its plain meaning. Florida legal precedent has made abundantly clear that the courts may not look beyond the plain meaning of the statute to render meaning. In State versus DeBorn, the court says when a statute is clear, courts will not look behind the state's plain language for legislative intent or resort to rules of statutory construction to ascertain its intent. And referring to Paul versus State, the court says, rather, the court will first look to the language of the statute itself because the statute's plain and ordinary meaning best reflects the legislative intent. This ruling was subsequently upheld in Florida Supreme Court in March 16, 2017. So when we apply the doctrine of plain English, section 768.79 is unambiguous. A settlement offer must name the parties. It's very clear. In this context, the phrase can only have one meaning, that is to render the distinct name of the party into the body of the proposal. It does not say infer, imply, deduce, indirectly identify, or otherwise refer to the party. Now, the language is a little bit different in Florida's Civil Proceedings 1.442 at paragraph C3. It says a proposal may be made by or to any party or parties and by any combination of parties properly identified in the proposal. Now, in this case, properly identified is spelled out in paragraph C2. The method of identifying the parties is to name the party or parties. Furthermore, paragraph C3 states that the identification must be properly identified in the proposal, that is, inside the proposal. The settlement proposal we have here does not name the parties in the proposal. Instead, it Instead, it references an undetermined plaintiff and defendant, and these references are not at all defined in the settlement proposal itself. Furthermore, the general release, which was not filed with the settlement offer, was written solely by the appellee and is a separate document. The general release states it is between the City of Treasure Island and the non-existent or unknown party, Stephen Whelan, that is spelled S-T-E-P-H-A-N. But it suffers from the same defects of construction validity as the settlement proposal itself does. Furthermore, it's a unilateral document, and so it's not eligible for any relief under the Schreiber doctrine. Now, to my next point.
You've used 4.5 minutes so far.
Sorry?
You've used 4.5 minutes.
Okay, thank you. Okay, the filing header caption is not part of the settlement proposal. I'm sure you're all familiar with the standard form of filings with the court. Obviously, this caption is added to the body of anything that's submitted to the court. It's my contention that this caption is actually not incorporated by the act of filing. For example, when my former attorney filed my driver's license, this caption was clearly not incorporated into the driver's license, and if I decided to, for some reason, file with the court a copy of the Bill of Rights, then of course the caption would not be incorporated in the Bill of Rights. It's clearly a filing aid and attaches whatever document is submitted to the court filing system under the correct case. So going back to the Florida Civil Procedure 1.442 C3, it states that the identification must be properly identified in the proposal. And you can, as I just described here, clearly the identification is not in the proposal itself. One of the things that the appellee claimed is that that my former attorney had actually used the incorrect naming Stefan himself, but this is a little bit disingenuous because the source of the error was the police officer that was arrested, and he made the spelling mistake, which actually found its way into the criminal case, which was dropped because of lack of evidence very quickly. But that error did propagate then through the civil case initially. Once I took over the case, I never used the incorrect name, and I've always used the proper name. And in fact, in April the 20th, I filed the motion of substitution of counsel and a correction of the plaintiff as my first action as representing myself. Unfortunately, the court still has not made that change. Now, on to point number 5, a Schreiber error is not permissible in the case of a settlement offer that is not accepted. Relief under the Schreiber doctrine is only applicable for mutual documents that both parties intended to execute. It is explicitly not applicable to unilateral documents. An unaccepted settlement offer written by just one party is by its nature a unilateral proposal, not a mutual document. Nor it is a document that both parties intended to execute. And if as the person receiving the offer here, why would you want to sign up to an agreement that you knew that was both defective and probably void? As the sole drafter of the settlement proposal, the appellee is solely responsible for the context and accuracy and compliance with the law. Under the Fulks case, that's 343 BR 701, the court says, however, a party's performance under a contract is not excused on the basis of a unilateral mistake when the mistake is the result of the party's own negligence or lack of foresight. And the other party has relied upon his performance so that rescission would be inequitable. And under Feldman versus Critch, the court says a mistake is mutual when parties agree to one thing, but then due to either a Schreiber's error or inadvertence express something different in the written instrument. Such relief, however, is not available if it was a unilateral mistake, and it refers to DR Lakes and also Limehouses versus Smith. So, in short, what we have here then is a standalone unilateral document which does not name the parties. Instead, it uses undefined references, plaintiff and defendant, and a caption outside the settlement agreement itself that incorrectly identifies the wrong plaintiff. The errors cannot be cured by Schreiber because it was a unilateral document. In other words, what we have here is an invalid settlement proposal, and therefore the trial court orders that are associated with it should be deemed invalid also. Now, I'd like to get to the defenses that the appellee has argued, and most of them seem to be associated with arguing that a potential ambiguity exists. But it appears to be a bait-and-switch tactic in my view, because the appellee contends that the name error caused an ambiguity and then presents defenses and citations for defective ambiguity cases. but most of those cases relate to proposed terms and conditions of mutual agreements, not unilateral settlement proposals that were not accepted. In those cases, of course, the Shriner relief is not applicable. The reality is there is no ambiguity. It's very clear that the agreement itself does not name any party, and the caption names the wrong party. So whichever way you look at it, it really is not properly constructed and does not meet the requirements of statute or the civil procedures. The appellee cites Floyd versus Smith as their most significant case. In this case, the court rejected the assertion that a typographic gender error in the proposed settlement resulted in an ambiguity that would have affected appellant's consideration of the proposal. However, the gender error that they were talking about was the use of the word his rather than the word her in an agreement. And clearly that is an irrelevant point, because this section 768.79 and Florida Civil Procedures 1.442 say nothing about the need to put gender in a settlement proposal. So the Floyd case is really largely irrelevant in this case. Similarly, the appellee cited embroiderme.com versus Travelers, and once again, this is largely irrelevant because it was referring to a poorly drafted release, not the settlement proposal itself. And again, the release requirements are not defined in the relevant statute here. So again, it doesn't seem to be on point. Ultimately, here, what we have is a problem of defective ambiguity. It is not a problem of defective ambiguity. It's a problem of defective construction and a void agreement. There really is no ambiguity. Instead, there's just a valid agreement that does not comply with statute or civil procedures.
You've used 12 minutes.
Okay. I'm on to the last point now here. Which is that the failure to disclose and the concealing of the existence of an insurer was not in good faith. Section 768.79 at paragraph 7A says, if a party is entitled costs and fees pursuant to the provisions of this section, the court may, in its discretion, determine that an offer was not made in good faith. In such a case, the court may disallow an award of costs and attorney's fees. Now, as you know, among the most paramount considerations when considering settling or pursuing a lawsuit is the evaluation of the party's financial situation, and particularly whether a party is covered by insurance, and of course the scope of the limits of liability and so forth. Therefore, failure to disclose or even conceal the existence of insurer is an act of bad faith. I only became aware of the existence of the assurance when Bell and Roper, the attorneys here, provided statements to justify the reasonableness of their attorneys' fees, and that was about 4 years after the settlement proposal was written. Before that, we had no knowledge that an insurer was involved. And as can be seen by the billing statements, which are part of the record, almost all of the reimbursement checks were payable from the insurer PIGIT, and administered by PCGS, which is based in Lake Mary, Florida, directly to reimburse the attorneys here, Bell and Roper. None of them appear to be billing the appellee, which is based in Treasure Island. Of course, it's clear that the insurer is really pulling the strings here, because Lake Mary is just a suburb of Orlando, where the attorneys are based, and Treasure Island is the appellee in this case is located about 150 miles away. So all of the while, really, this case has been controlled and by the insurer, who had ultimate liability, and it appears that the control of this case as well. So in my opinion, I would say the concealment of the insurer is not an act of good faith. Now, one of the problems with not knowing there's an insurer is that the appellant is denied the right to include the insurer as a party in this case. And concealing the insurer is problematic because, as the court will be aware, there is a lack of mutuality of obligation with regard to the risk of liability for attorney's fees for the prevailing party. And by that I mean the prevailing party cannot claim fees and costs against an insurer unless they are named as a party explicitly in the settlement agreement. And that's under Sparks and Barnes.
15 minutes. So you have 5 minutes left.
Okay.
You can save them for rebuttal. You can burn them up here. It's up to you.
Yeah, can I just take 2 more minutes and have
They're
3
your 5
remaining?
minutes, so use them as you wish.
I'm sorry?
I said they're your 5 minutes, so use them as you wish.
Okay, all right. In the case of Sanchez versus Sink, and Sink is spelled C-I-N-Q-U-E, the court stated a proposal for settlement must state with particularity any relevant conditions and all monetary terms. In citing Palm Beach and Polo Holdings, the court says the proposal should be specific enough as possible, leaving no ambiguity so that the recipient can fully evaluate the terms and conditions. It seems to me the only way to state this with particularity and be as specific as possible is to name the insurer and to provide details of what coverage it has. However, this did not occur, and I believe it's not an act of good faith. Getting back to Florida Procedure 1.442, paragraph C2 at B, it says that a settlement proposal shall state that the proposal resolves all damages that would be awarded in a final judgment in the action which the proposal was served. But how can all claims be resolved if the dominant party is hidden and could later be potentially added to the litigation if discovered? Appellee claims that we should have been aware of the insurer because a general release was attached to Appellee's settlement proposal, and that document referenced an insurance company. However, the record shows that the Appellee's filing for the settlement proposal did not include the general release, but this release was a separate document not filed with the court. And the separation of this settlement proposal and general release underscores the fact that these documents were created standalone. Putting aside the validity questions, the above wording cannot be reasonably considered as a disclosure of the existence of an insurance company. Their catch-all list clearly defines non-specific entities such as elected officials, which we don't think there were any involved. In addition, the phrase persons or entities in privity with Treasure Island is so broad it's really meaningless, and certainly not a reasonable disclosure of the existence of an insurance company. And certainly it does not meet the requirements in Sanchez versus Sink that require it to state with particularity and be as specific as possible. Concealment of the insurer is an act of bad faith. Also, on the final point here is that the appellee contends that the insurance adjuster was at the mediation conference in this matter and was required to attend, but there is no evidence of this, and we were certainly not aware of that. And I would like to leave it there, and if I have any time remaining, I'll use that
2 minutes.
For rebuttal. Thank you.
May it please the court. My name is John Janicek. I'm the attorney representing the city of Treasure Island in this appeal. As Mr. Whelan touched on, the primary issue on this appeal is the requirement to name the party making the offer and the party to whom the offer is being made. That's the requirement both under Florida Statute Section 768-79 and Florida Rule of Civil Procedure 1.442. Neither of those provisions, however, provide how a party is to name the party to whom it is being made or the party making the offer. Instead, it really simply requires you to identify the offeror and the offeree, which is exactly what the city did here. With the proposal for settlement, the proposal reads, defendant proposes to settle plaintiff's claims asserted via this lawsuit against defendant. It also stated this proposal is being made by defendant to plaintiff. The case caption style of the proposal clearly identifies Stephen Whelan, the sole plaintiff in this case, and the City of Treasure Island, the sole defendant in this case. This was the exact same spelling of Mr. Whelan's name that Mr. Whelan himself used in his complaint and in every filing with the court up to the date of the service of this proposal for settlement. In fact, it's the same spelling that he used in many filings subsequent to that date as well. In fact, it wasn't until approximately 3 years later that he ever filed anything with the court to correct the spelling of his name. We simply used the spelling that he was using. The fact is, the use of the phrase defendant and plaintiff in the body of the proposal for settlement and the purported misspelling of Mr. Whelan's first name, those considerations really miss the issue of an analysis of a proposal for settlement. As Mr. Whelan stated in his oral argument today, a proposal for settlement must state with particularity any relevant conditions and all non-monetary terms. It's a particularity requirement. What that means is that we have to avoid any reasonable ambiguities in making a proposal for settlement. Now, the 4th DCA in 2010 and Nationwide Mutual Fire Insurance Company versus Pollinger identified and explained what an ambiguity is. It's defined as the condition of admitting more than one meaning. Your Honors, there is no more than one meaning in this proposal as to the identity of either the offeror or the offeree. Again, at all times throughout this litigation, there's been only one defendant, the city. There's been only one plaintiff, Mr. Whelan. And we, in fact, use the same spelling of his name that he himself used up to that date, the date of the service of the proposal for settlement. There could be no reasonable alternative interpretation of who the defendant was when we're referring to the defendant in the proposal for settlement, or who the plaintiff is when we refer to a plaintiff. It must be the sole defendant, and it must be the sole plaintiff. Furthermore, on Mr. Whelan's point about incorporation of the case style into the body of a document, he hasn't cited to any case law saying that you're supposed to ignore the case style or what comes above the body of a document. And instead, contrary to his point, in Sanchez v. Cinque, that's a Florida 4th DCA case from just last year, 2018, the court explained that a proposal for settlement must be read as a whole. Reading this proposal for settlement as a whole, there is no doubt that the only plaintiff in this case was Mr. Whelan. The only defendant in this case was the city, and the defendant was proposing a settlement to the sole plaintiff. There is no other reasonable reading of this proposal than the one defendant making a proposal for settlement to the one plaintiff in this case. Additionally, the Florida Supreme Court in Allen versus Nunez, that's a Florida Supreme Court case from just last year, again, 2018, it explained that in proposals for settlements, they're intended to end judicial labor, not create more, as is what has happened in this case. On that point, it said that it was discouraging nitpicking in proposals for settlements to search for ambiguities. That's exactly what Mr. Whelan is attempting to do with his appeal, and today he is attempting to nitpick the proposal for settlement to find some kind of ambiguity. The fact is, for all the reasons I've already stated, there is no ambiguity in the proposal for settlement. The city didn't misspell his name. We simply used the same spelling of his name that he himself used. We also identified the sole plaintiff and the sole defendant in the case as respectively, the offeree and the offeror. To the extent that there may have been some kind of misspelling, it's simply nitpicking. And it's nitpicking to say that, well, you didn't name, you didn't spell out the actual name of the plaintiff or the actual name of the defendant in the proposal in the body of the proposal for settlement. Again, that's not, that only becomes an issue if there's some kind of ambiguity, if there's some kind of condition that has more than one meaning. There is only one meaning in this case. It's that the sole defendant, the city, is making a settlement offer to the sole plaintiff, Mr. Whelan. Furthermore, in identifying ambiguities, the Florida courts have noted that ambiguities are only going to be material if they somehow prevent the offeree from being able to fully evaluate the terms and conditions of a proposal for settlement. Mr. Whelan, in his oral argument today and in his briefs filed with this court, has not explained how this purported ambiguity, which again, we don't believe there's any ambiguity here, he's failed to explain how this purported ambiguity would ever affect his ability to understand the terms and conditions of the proposal for settlement. Failure to identify that deficiency warrants a rejection of all of the arguments that he's making. On that issue of the misspelling of his name, a couple of points there. Number one, as I've covered already, it was a self-inflicted error on Mr. Whelan's part, or at least via his counsel. Now, he wants to blame the probable cause affidavit that was at issue in this case. But again, there isn't a police officer who filed this case. There isn't a state attorney who filed this civil lawsuit. It was Mr. Whelan who filed this civil lawsuit with the aid of his attorney. If his attorney or Mr. Whelan himself made a mistake in filing the case and in spelling his name with an A instead of an E, that's their fault. And the city should not be prejudiced or punished for using that exact same spelling when it serves Mr. Whelan with a proposal for settlement. And as a corollary to that point, I could see a situation where we could turn this on its head, and let's say that this city did attempt to spell his name correctly using the correct spelling of his name either in the case caption or in the body of the proposal for settlement. I believe that we would be right back here today, Your Honors, because then we would have either two different spellings or a spelling that didn't match the complaint or the docket or any of the other documents that had been filed in the case. Again, I think that that would ultimately be an irrelevant point because ultimately there was only one plaintiff, there was only one defendant. There can be no confusion as to who the offeror was and who the offeree was in this proposal for settlement. Mr. Whelan identified a couple of cases that are cited in the city's answer brief, one being Embroidme.com, Inc. versus Travelers Property Casualty Company of America. That's a Southern District of Florida case from 2015 where the Southern District was applying Florida law, analyzing a proposal for settlement. Mr. Whelan thought that that case is irrelevant. The issue in that case was whether or not a release that was incorporated by reference into the proposal was ambiguous, which is exactly really what the issue is in this case. The allegation was that the release was ambiguous because there were paragraphs in that release that were poorly drafted. They referred to non-parties to the lawsuit to whom the offeree would have to release certain claims. The court found that although it was poorly drafted, that is not a determining factor. Typos or referring to non-parties doesn't necessarily mean that there is an ambiguity. Furthermore, it stated that even minor ambiguities should not have prevented plaintiff from accepting defendant's proposal. Even if we were to accept Mr. Whelan's argument here today and find that there are ambiguities in this proposal for settlement, which again, the city absolutely disputes, but even if we were to assume that arguendo, the fact is ultimately this would at most be a minor ambiguity because again, we have one plaintiff, we have one defendant, we have the one defendant, the city, making a proposal for settlement to the one plaintiff, Mr. Whelan. The city also cited to Mathis versus Cook, which is a Florida 5th DCA case from 2014. That case also involved a proposal for settlement that incorporated a release that required the release of certain co-defendants. The court again found no ambiguity because the terms were very clear. The court also in a footnote noted that there were typographical errors in the proposal for settlement. Again, the court found that that really doesn't matter because it doesn't create a reasonable ambiguity that would affect the offeree's ability to understand the terms and conditions of the proposal. And that's, again, the driving factor in this case, whether or not there's an ambiguity in the city's proposal that would affect Mr. Whelan's ability to understand the terms and conditions thereof. There's simply not. The one that he's identified, the identity of the offeror and offeree, there's no ambiguity there. It's very clear who the offeror is and who the offeree is. Floyd v. Smith, that's the Florida First DCA case from 2015. Mr. Whelan also argued that that is irrelevant to these proceedings. Well, in that case, you actually had a typographical error that referred to a male when the offeree was actually a female. It referred to releasing his claims when it should have referred to releasing her claims. That case is absolutely relevant to this case because that typographical error goes to the issue of the identity of the offeree. Here, once again, we have an issue dealing with the identity of the offeror and the offeree. The court there, even though you had the offeror was citing to the completely wrong gender, found that nonetheless, we know who the offeree is. Why? Because no one but the appellant had asserted any claims in the case. Just like Floyd v. Smith, no one but the appellant, Mr. Whelan, in this case, ever asserted any claims in this case. There can be no doubt as to who the identity of the offeree is in this case. It was always Mr. Whelan. It was very clear that it was always Mr. Whelan. Next, Your Honors, Mr. Whelan also takes issue with the city's failure to disclose or identify its insurance carrier provider in the proposal for settlement. Well, as Mr. Whelan very clearly explained in his oral argument, Rule 1.442 and Florida Statute Section 768-79 requires that the offeror identify the party making the offer and the party to whom it is made. It doesn't require the offeror to identify anyone but parties. Parties are parties to the litigation, the plaintiff, the defendant. At no time during this litigation has the insurance company ever been a party to this case. It's never been a plaintiff, it's never been a defendant. There was no requirement under either 1.442 or 768-79 to identify the city's insurance carrier in this proposal for settlement. Mr. Whelan also takes issue with the fact that apparently he didn't know that the city had a carrier that was involved in this case. Your Honor, that is something that he or his counsel could have discovered through very standard discovery. Quite frankly, I'm not sure whether or not he took that avenue during the underlying litigation, but it's certainly something he could have done. Regardless, that is wholly irrelevant to the issues in this case because neither 1.442 nor 768.79 requires the city disclose any insurance that it may have had at that time. Furthermore, that issue of disclosure and identification is wholly irrelevant to the issue that he's actually arguing, which is whether or not the trial judge committed error, an abuse of discretion, in rejecting his arguments and finding that the city's proposal was made in good faith. Both 768-79 and 1.442 allow the trial judge's discretion to not award attorney's fees after a rejection of a proposal for settlement, where the trial judge finds that the proposal was not made in good faith. Analyzing the issue of good faith doesn't turn on, however, the knowledge of the offeree. In other words, it doesn't turn on the knowledge that Mr. Whelan had at the time of the offer. It doesn't turn on whether or not he knew that the city had insurance or the city had money to cover the proposal. What it turns on is the knowledge held by the offeror, the city. It turns on whether or not the evidence known by the city at that time to evaluate liability and damages, and that's it. Mr. Whelan has not cited any case law or other authority that go to those issues. He also did not cite any case law or legal authority that went to those issues when he was presenting this argument to the trial judge. The issues relating to the disclosure or identification of insurance have nothing to do with the knowledge held by the city at the time it made its proposal for settlement, and it has nothing to do with the analysis of good faith under 1.442 or Section 768-79. Therefore, they're wholly irrelevant to the issues before this court. Finally, Your Honor, Mr. Whelan didn't touch on this, Your Honors, Mr. Whelan didn't touch on this in his oral argument yet today. But one other thing that he is appealing in this matter is the court's denial of his motion for rehearing or reconsideration on these same issues. In his motion for rehearing or reconsideration, he simply reiterated the same arguments that he had already presented to the court and which the lower court had very thoroughly analyzed in its order awarding attorney's fees and costs to the city. A trial court's decision on a motion for rehearing is reviewed for abuse of discretion. Mr. Whelan has yet to identify any abuse of discretion committed by the lower court in denying his motion for rehearing or reconsideration. In particular, he hasn't cited to any error, omission, or oversight committed by the lower court in denying that motion for rehearing or reconsideration. And as such, the arguments he makes, like I said earlier, he hasn't made any arguments in this appeal regarding that, even though he does in his notice say that he's appealing that denial. But for the reasons I've stated here today, the appeal of that denial is wholly without merit and must be rejected. For these reasons, the city maintains that this court should affirm the lower court's order and supplemental judgment for the city dated April 10th, 2017, as well as the lower court's amended order denying the plaintiff's motion for rehearing and reconsideration dated September 4th, 2018. And if I do have any more time, if Your Honors have any questions, I'd be happy to answer those.
We're good, sure.
Thank you, Your Honors.
Thank you.
Thank you. How much time do I have? 2 minutes? Okay. Again, the appellee is talking about ambiguities. There is no ambiguity. There is simply an error here. The statute 768.79 is clear. The parties must be named. There is no excuse to say that my former attorney had used the incorrect name because on 3 occasions we had interrogatories that made the correction of the name long before that settlement agreement was put together. In addition, we corrected the deposition data that also had that correction. That happened a long time before. And then because this is a unilateral document, there is no excuse for the error under Schreibner. He also pointed out on Rule 1.442 on paragraph C3 that it refers to making offers between parties, but it says specifically the parties must be properly identified, and then in paragraph 2, properly identified means name the parties. It does not mean reference the header, which includes a name that is not the name of the individual. So, from whichever way you look at it, it seems to me that they're asking us to basically agree and sign a agreement that we know would be void and does not meet the requirements of the statute, which seems to me to be an unreasonable request. And I think with that, I'll leave it there. Thank you very much.
Thank you. Thank you both. Court will be in recess for